Hello students, we now begin with charting the subject of private international law. In the first lecture, we had a basic introduction to the global positioning of this subject, its utility and its relevance. In this lecture, we try to understand the first and the fundamental premise of private international law related to the jurisdiction of the local courts in a matter which has a foreign element attached to it. Now, jurisdictional questions in the domain of private international law are different from similar questions in public international law. Here, in private international law, they are largely related to issues of procedural law. In matters with a foreign element attached to it, an additional question arises. Does the local court possess jurisdiction to try that suit? Thus, establishing the jurisdiction of the local court in matters with foreign element is the prime issue in private international law, as without answering this question, no further judicial activity can be undertaken in that matter. Now, two fundamental questions need to be addressed at this stage. They are against whom an action can be filed and who can file that action. The second question is what type of actions may be filed. Disputes before the court on questions of jurisdiction are classified under three heads. They are actions inter partes or personal actions, actions relating to property, and actions relating to status. Actions inter partes or personal actions are an action that seek to establish the rights of the disputing parties arising from a contractual or a tortious liability based claim. Now, what is the basis of jurisdiction? Local courts jurisdiction exists because it would be possible to serve the processes on the defendant except when such process ought to be inevitably invalidated and quashed if such presence of the defendant was procured by force or fraudulent means. The general rule of the presence of the defendant is based on the opinion that all persons on the territory of a country are deemed to have submitted to the laws of that country. This principle required only the presence of the defendant, and residence of the defendant has not been insisted upon. If, having been served the summons, he had left the country, it would in no way affect the jurisdiction of the court to decide that dispute. Further, in case of multiple defendants, most common law systems, including India, require that such processes ought to be served on each of the defendants to make them submit to the jurisdiction of the local court. Now, foreign corporations similar to firms are subject to the local court's jurisdiction depending upon the place of domicile in matters of incorporation, dissolution and winding up, and in matters of amalgamations. Presence in the territory of the local court jurisdiction is enough to bring them under the jurisdiction of the local courts, notwithstanding that the company was wound up in the parent country of its domicile. A few instances when an English court exercises jurisdiction to order service outside its jurisdiction are where the whole of the subject matter is land situated within its jurisdiction, or is any action affecting such land but not related to issues regarding the value of such land. Defendant is domiciled or ordinarily or habitually resident within its territorial jurisdiction. Claims for administration of the estate of the deceased domiciled in England or such questions arising out of administration of such estate. Claims for executing trust property situated in England, claims inadmissible if the trustee sold the property and left England. In contract claims for enforcing, rescinding, dissolving, annulment or action for damages where the contract was either made in England or is made on behalf of a trader residing in England or is governed by the English law. Claims on a tort committed in England or injunctions for refraining the defendant against a possible activity in England. Where an action is brought under the Carriage of Goods by Road Act, Merchant Shipping Oil Pollution Act or the Nuclear Installation Act, English court's jurisdiction exists even if the claimant is a foreigner or the claim arises out of an action outside England. In actions of mortgage of movable property situated in England, English courts exercise jurisdiction. Court's jurisdiction under the Civil Procedure Code, sections 19 and 20 for actions inter partes arise in the following situations. 1. When the defendant's permanent or temporary residence is within the jurisdiction of the court. 2. If the defendant is engaged in some business that falls within the court's jurisdiction. 3. If the defendant is making a gainful employment in the area falling within the court's jurisdiction. 4. If the cause of action, either in whole or partially, arises within the said jurisdiction. In Gurdayal Singh versus Raja of Faridkot, the Privy Council opined that jurisdiction being territorial and it should generally be with the courts of the state where the defendant resides and not at the place of cause of action or a contractual claim at the locus solutionis. Indian courts have consistently affirmed their jurisdiction in matters where the defendant was present, either directly or through an agent, or has some business within the local territory, irrespective of the cause of action arising within that territory. Civil Procedure Code on service of summons for defendants residing outside India provides that summons may be served on the agent of the defendant, recognized agents holding power of attorney and authorization on behalf of the defendant, the manager or the agent who carries on the defendant's business if the defendant is residing outside the territorial jurisdiction of the court. If the suit is for compensation for wrongs against immovable property, no agent has been appointed for the service of the summons. It may be made upon any agent of the defendant in charge of such property. The defendant could submit to the jurisdiction of the court through an express agreement or by conduct, through a solicitor's endorsement of the summons or an application for security of cause. However, submission to the jurisdiction cannot bring before the court matters otherwise outside its jurisdiction. For example, immovable property situated outside its jurisdiction. Courts do not assume jurisdiction if convinced that their orders would be ineffective. For example, in respect of a tort committed on a land that is outside their jurisdiction. Courts could entertain counterclaims against the plaintiff foreigner in the same matter. Filing an affidavit by the defendant and his appearance to contest on merits does not provide jurisdiction to the court. An express stipulation in a contractual document, not implied, could accord jurisdiction to the local court, as the parties, despite being foreign, have agreed to such jurisdiction. Now, the Indian law on submission to jurisdiction. Now, the jurisdiction of Indian court exists if the foreigner defendant makes an unconditional and unequivocal appearance and pleads the case on merits. Waiver of objections to jurisdiction also amounts to submission to jurisdiction. Similar opinion was expressed in the Bahrain Petroleum Corporation Limited versus P.J. Pappu. Long and continued participation by the defendant in the proceedings without any protest may amount to a waiver of objection to jurisdiction. The next question is, who can file a suit? English private international law specifies that any person who is not an alien enemy can bring in a suit before the English courts. The test is based on territoriality and not on nationality. If the foreign national belonging to an enemy country is having his business in the United Kingdom or allied or neutral territory, he is not seen as an alien enemy, but is treated as an alien friend. A company may also be invested the character of an alien enemy if it is incorporated in the alien country or if its directors come within the meaning of the alien enemy. Similar position prevails in section 83 of the Indian Civil Procedure Code, applicable also to foreign corporations. In absence of a declared war, people carrying on business on that territory shall not be declared as alien enemy. An alien enemy per se cannot sue in Indian courts except with an express or implied permission from the Government of India. Through section 84 of the Civil Procedure Code, a foreign state can sue in any competent court in India if the object of the suit is to enforce the private rights and not the political rights of that foreign ruler or any officer of such state in his private capacity. The second aspect of jurisdictional questions are related to actions with respect to property. Actions in respect of property are classified into three categories: actions in rem, actions in respect of immovable property, and actions in respect of movable property. Actions in rem are again of three kinds: those that determine the title or right to the possession of the property, admiralty actions relating to ships within territorial waters, and actions affecting personal status. Since the last century, however, much of the actions in rem are now perceived as actions in personam, leaving just the admiralty actions in that division in the High Court as actions in rem. Actions in respect of immovable property are ordinarily governed by the law of the citus of the immovable property. However, few actions could still be made before courts at the forum under Section 31 of the Civil Jurisdiction and Judgments Act 1982 CJJA in matters of trespass to or any other tort affecting immovable property in a foreign country. The case of Ray Polypek International PLC is one of the most important cases on this subject. The case concerned properties in northern Cyprus owned by the plaintiffs, which were appropriated by the Turkish government. The plaintiffs alleged that Polypek, a company in administration, had trespassed on their property by encouraging Polypek's subsidiaries to occupy it without authority. The defendants objected to the jurisdiction of the English court, and the plaintiffs argued that the application of Section 31 of the CJJA Act 1982. It was held that by virtue of this provision, the English court had jurisdiction to hear proceedings for trespass to immovable property, even though the property was situated abroad, provided that the proceedings were not mainly concerned with the question of title or the right to the possession of the property. Actions in respect of movable property are treated on the same lines as actions inter partes, and a suit is for compensation for wrong done to the movable property if the wrong was done with the local limits of the jurisdiction of one court and the defendant resides or carries on business or personally works for gain within the local limits of the jurisdiction of another court. The suit may be instituted at the option of the plaintiff in either of the said courts. Warsaw Convention of 1929 as amended by the Hague Convention of 1955 regarding the principles of jurisdiction on the carriage by air states that claims by the plaintiff for relief can be made in the territory of one of the high contracting parties to the Warsaw Convention at any of the following places: A. Before the court at the place of destination, at the place where the carrier ordinarily resides or has his principal place of business, or has an establishment by which the contract has been made. The Guadalajara Convention of 1962, a supplement to the Warsaw Convention, ensures that relief claims can be made against the actual carrier, ensuring that courts at the place of the business of the actual carrier shall have jurisdiction. The Geneva Convention of 1952 states that a claim can be preferred in any court or tribunal in any country within whose territory A. the defendant is ordinarily resident or has his principal place of business, or the place of the agent through whom the contract was entered into. B. at the place where the goods under the contract were taken by the carrier, or at the place where the goods were designated to be delivered. The Brussels Convention on Civil Liability for Oil Pollution Damage of 1969 states that action for damages can be initiated in the courts of the contracting state where the damage has occurred. The Berne Convention concerning the carriage of passengers and luggage by rail of 1961 and the additional convention relating to liability for death of and personal injury to passengers of 1966 envisage the jurisdiction on the courts of the state to which the defendant railway, including the operating railway, belongs. Paris Convention on the Third Party Liability in the Field of Nuclear Energy 1960, the Brussels Convention 1963, the Vienna Convention 1963 suggested that state parties impose absolute liability on operators, including foreign operators. Jurisdiction primarily stays with the courts of the contracting party where the nuclear incident occurred. The immunity from jurisdiction, personal and property is provided to foreign state, its head and its departments, persons entitled to diplomatic immunity, and officials of international organizations including United Nations and its organs. A foreign sovereign and his agent in his representative capacity cannot be impeached directly and indirectly in respect of his person and property. No suit for damages will lie against the foreign sovereign personally or for any possession in his control. The immunity extends to government departments and in a limited space to foreign state corporations. Diplomatic immunities crystallized in the Vienna Convention on Diplomatic Relations 1961 classified such personnel into three categories: the diplomatic agent, members of the administrative and technical staff, members of the service staff, domestic helps, chauffeurs and porters, etc. Member states accord complete jurisdictional immunity to representatives and official staff of the international organization. The Indian law is also on similar lines to the Vienna Convention of 1961. Sections 84 to 87A of the Civil Procedure Code require the court to take judicial notice of recognition of a foreign state and a foreign government. Section 86 Civil Procedure Code confers jurisdictional immunity to a head of a foreign state, ambassador or envoy of a foreign state, high commissioners of the Commonwealth states, and members of the staff of the head of the foreign state, ambassador, high commissioner, as the central government may by general or special order specify in this behalf. These categories may not be subject to any judicial proceedings in any court in India except with the consent of the central government. The immunity extends to all civil actions. The aforesaid persons cannot also be arrested under any provision of the Civil Procedure Code. Consent for the judicial action may be granted only in the following situations: A. When the foreign state is in possession of immovable property within the territorial limits of the local court and the suit is with regard to such property or for money charged thereon. B. When the foreign state has expressly or impliedly waived the privilege accorded to it. Judicial opinion in this country has been that the consent is an important requirement as a matter of policy. Such consent has to be obtained before the institution of the suit, else it would not be a valid consent. The principle of Lex Foreign is one of the important principles of private international law concerning jurisdiction. The term Lex Foreign literally means the law of the forum, where the dispute is being adjudicated upon. all procedural matters are governed exclusively by the law of the forum. It would make no sense if the exercise of jurisdiction by the authorities of one state were regulated by the law of a foreign state. The exercise of jurisdiction is regulated by procedural law. Because procedural law regulates the public service of rendering justice, it can only be regulated by the law of the forum. As Cheshire puts it, the substantive rights of the parties to an action may be governed by a foreign law, but all matters appertaining to procedure is governed exclusively by the law of the forum. In cases that have a foreign element, such as nationality or domicile of the parties, or the place of the execution or performance of a contract, the judicial authority of the forum will abide by its conflict of laws rules to determine the application of foreign law to the substantive aspects of the disputes. Now, exception to the Lex Foreign rule is called as Lex Causae. Judicial procedures have a twin objective perspective. One, to regulate the exercise of jurisdiction by the local authorities, and two, to end a legal dispute based on substantive law. To accomplish these two objectives, there are rules of procedure that deal with the exercise of jurisdiction and are regulated by Lex Foreign, and rules of procedure related to the substantive law that will be applied to the dispute. The second group of rules is not regulated by Lex Foreign. Instead, it is governed by the law that is applied to the merits of the dispute, Lex Causae. Alfred initiates a suit in his country against Bob, domiciled in another country. Then, the procedural aspects of the suit ought to be governed by the law of Alfred's country, since that is the forum where the dispute is being adjudicated. The law of the country of Bob shall apply to those acts like service of summons, and evidence shall apply since they happen in that country, as well as the rights which are questions of substantive nature. If the law of a third country is to be applied to the merits of the dispute because the parties have so determined, this law must also be taken into account for some specific procedural matters. In the above example, if a third country's law is agreed upon by the parties as applicable law and it is to be applied to the merits of the case, this law will also determine which party carries the burden of proof. As it is largely seen as a question of substantive law regarding the rights that are being claimed, they are also tried to the merits of the case and should be regulated by the same system of law that applies to its merits. This rule was adopted by the 1980 Rome Convention on the law applicable to contractual obligations. To conclude, we have now discussed the fundamental rules regarding the jurisdiction of courts in disputes with a foreign element. Some of these basic rules are: number 1, actions against persons require the presence of the defendant or his submission to the jurisdiction of the court. Number 2, actions against immovable property adopt the rules of the citus of the property, but in matters like trespass or other torts, an action can be brought before a local court. Number 3, actions with respect to movable property follow the same rules as actions against persons. Number 4, immunity from jurisdiction is available to heads of foreign state, diplomatic personnel in their official capacity, and to members of the international organizations in their official capacity. So, now we have understood the first principle of private international law, that is the jurisdiction of courts located in the forum where the suit has been adjudicated in matters which have a foreign element attached to it.